And Paula Reed joins us now from Washington to help sort out some of those questions. Paula, thanks for being with us. Kim Davis is not authorizing these licenses, so will they be valid?
Elaine, we just don't know whether or not the courts will ultimately find that these licenses are valid. What we do know is that the Attorney General of Kentucky says that he believes they are valid. But he never filed anything with the court. And had he filed something with the court while she was in prison or even in the next few days, that would carry considerable weight with the court when they try to decide whether or not these are valid. These will inevitably be challenged. This will go to court, but it is unclear. Legal experts say we just don't know whether or not they will be found to be valid.
Paula, another big question. Could Kim Davis make it to the Supreme Court? Her lawyer seems to think so. We spoke to him earlier. First, let's listen to that.
The fact of the matter is the Supreme Court did not address any issue with regards to religious accommodation. And in fact, the dissenters and everyone who watches this opinion clearly understands that these kinds of reasonable accommodation requests are coming back to the Supreme Court. It's one thing, for example, to have some kind of ruling, whether it's a court order or a statute, and then just simply ask for a reasonable accommodation based upon religion. That's required by not only federal constitutional law, but federal and state law as well. And so that is something that has been very much part of who we are. Not violating a law, but having a reasonable accommodation to accomplish the interest at issue without violating your conscience. And so that's what Kim Davis's case is about. It's not a direct challenge to any particular court ruling. It's just asking for a reasonable accommodation. And whether this case or some other case like her goes up to the Supreme Court, there's no question that these kinds of cases will be back before the High Court in not too distant future.
Is that the goal here, Paula?
That is absolutely the goal, to get Kim Davis's case or some case like hers before the Supreme Court and flush out the question of whether or not public officials have to comply with the Supreme Court's June decision and to what extent they have to comply. Now, there's no doubt that Kim Davis is a woman of strong conviction, but she is surrounded by very shrewd legal minds who are advising her and trying to sort of craft a case that could potentially make it before the Supreme Court. But so far, the Supreme Court is not biting. They had an opportunity a little over a week ago to grant her some temporary relief, and they passed on the case with just a one-sentence reply. Now, she still could make it before the Supreme Court, but most legal experts think this is not the case that will make it to the Supreme Court to help flush out these questions. It is more likely that a case brought by private business owners asking to what extent they would have to, for example, provide flowers for a same-sex reception or a cake for a same-sex reception. That is the more likely kind of case that would make it before the Supreme Court.
Kim Davis will not authorize the licenses, so could she go back to jail, Paula?
She could go back to jail, but it seems that the time that she spent in jail didn't have too much impact on her decisions here. It is more likely that the judge will not send her back to jail. It seemed that had the effect of almost making her somewhat of a martyr in the eyes of some people. So I think the judge will probably wait to see how this plays out in the office. As long as someone in the office continues to issue marriage licenses, that should keep Kim Davis out of jail. And then the question of whether or not those licenses are valid, well, that will have to be decided sometime in the future.
Paula, real quick before we go, we heard the lawyer, he's asking for a reasonable accommodation. They want her name, title, and authority taken off the marriage licenses. Has that ever happened before? Is there any precedent for that kind of a request?
There have been similar requests made like this, but this is very complicated because it's an automated signature in many of these cases. It's not even her actual signature that she wants taken off of it. So again, we don't know how that is going to play out. My guess is that the office, as they continue to issue these licenses, the question of validity will be decided later on. The question of whether or not her signature can be removed from these licenses, that'll probably be left up to the legislature. And, hopefully those questions will be resolved in the coming months.
All right. Paula Reed in Washington for us. Thank you.